Hello and welcome to Module 5 of International Criminal Justice. I am Professor Rashmi Raman and I will be taking you through this module titled The History of International Criminal Prosecutions, Nuremberg and Tokyo. The learning outcomes for this module are: firstly, why did international criminal prosecutions take place? How did they come into being? And what was the procedure behind them? And secondly, why did these criminal prosecutions fail? We will discuss two important historical trials, the Nuremberg trial and the Tokyo trial. First, the Nuremberg trial. In the immediate aftermath of Hitler's ascent to power as the German Chancellor in 1933, history witnessed a never-before-seen horror of about 6 million deaths. Hitler and his Nazi government ruthlessly murdered 6 million Jews, with another 4 to 6 million non-Jews, mainly gypsies. This was one of the first state-sponsored events known in history as the Holocaust. After a long-fought victory, the Allied forces, comprising of France, the Soviet Union, the United Kingdom and the United States, set up the International Military Tribunal, the IMT, at Nuremberg, Germany, to punish all the war criminals and bring justice to the victims of the war. Several Nazi political leaders and military leaders were prosecuted under this tribunal. The indictment lodged against them contained 3 counts. Firstly, crimes against the peace. This comprised planning, preparation, initiation or waging of a war of aggression or a war in violation of international treaties, agreements or assurances, or participation in a common plan or conspiracy for the accomplishment of any of the foregoing. Secondly, war crimes, that is, violations of the laws or customs of war. Such violations shall include, but not be limited to, murder, ill treatment or deportation to slave labor or for any other purpose of civilian population of or in occupied territory, murder or ill treatment of prisoners of war or persons on the seas, killing of hostages, plunder of public or private property, wanton destruction of cities, towns or villages, or devastation not justified by military necessity. And thirdly, crimes against humanity, that is murder, extermination, enslavement, deportation and other inhumane acts committed against any civilian population before or during the war, or persecutions on political, racial or religious grounds in execution of or in connection with any crime within the jurisdiction of the tribunal. The provisions of the London Agreement were accepted by 19 other nations. The tribunal, enabled by its own authority, could then seek any person guilty of the war crimes listed. This allowed it to bring in large organs like the Nazi Gestapo and its leader to the tribunal to be tried as war criminals. The defendants were given 4 entitlements in all. 1. A copy of the indictment. 2. An offer of any relevant explanation to the charges against each of them. 3. A counsel to represent them. And finally, a right to confront and examine the witnesses. Under the presidency of Gen.I.T.Nikitchenko of the Soviet Union, the first session convened on October 18, 1945 in the German capital, Berlin. From November the 20th, 1945, all subsequent sessions of the tribunal were held in Nuremberg under the presidency of Lord Justice Geoffrey Lawrence, later Baron Trevethan and Oaksey, the British members. It took 216 sessions for the tribunal to come to a verdict on 22 of the 24 original defendants on October 1, 1946. Of the 24, 1 had committed suicide and the other was too infirm to be tried. Of the remaining 22, 3 were acquitted of all charges. death sentence was handed to 12 of the accused. Life imprisonment was handed to 3. 4 were sentenced to terms of imprisonment ranging from 10 to 20 years. On October 16, 1946, 10 of the convicts were hanged. Martin Bormann was convicted to death in absentia, and Hermann Göring took his own life before his execution. The defendants had some defenses which were rejected. Some of these were that only a state could be guilty of war crimes and never an individual. This was countered by the tribunal by stating that all international crimes are the works of men, and only if they are punished could the international law be upheld. The defendants also pled that the trial and adjudication were ex post facto. However, the International Military Tribunal stated that the acts were criminal prior to the end of the World War, and the tribunal had the jurisdiction. Subsequent trials. From 1946 to 1949, 12 additional trials were held, all at Nuremberg. They lasted from December 1946 to April 1949. These trials were grouped together as subsequent Nuremberg proceedings, the acronym for which is SNP. These trials were before the judges of the military tribunal and not in front of the IMT. The Allied powers were falling apart on their terms and could no longer carry out the trials in unison as they had originally envisaged. The Nazis were particularly inhumane in their treatment of war prisoners. They conducted experiments on humans to achieve racial purity. Defendants who were accused of crimes against humanity were tried under the doctor trial. This was a particularly gruesome aspect of the Nuremberg Tribunal. 16 people were charged with aiding and promoting the Nazi plan for racial purity by implementing the eugenics law of the Third Reich. Subsequent trials dealt with high-ranking army officers, in which 12 were put to death, 8 were sentenced to life in prison, and 77 were sent to prison for various periods of time. The second part of the trials for today are the Tokyo trials. The Army of the United States, the supreme commander for the Allied forces in occupied Japan, was Douglas MacArthur. His proclamation led to the establishment of an International Military Tribunal for the Far East in Tokyo, Japan in 1946. It presided over the trials of senior Japanese political and military leaders pursuant to its authority to try and punish Far Eastern war criminals. The Potsdam Declaration of July 1945 demanded Japan's unconditional surrender and stated that justice shall be meted out to all war criminals. The Soviet Union alone did not sign it, as it was not in a state of war with Japan. Only China, the United Kingdom, and the USA signed it. After the signing, the European theatre saw Allied victory, while the Pacific theatre was still to be won. It was with the infamous dropping of the second atom bomb on Nagasaki that the United States of America managed to get Japan to sign the instrument of surrender. Japan surrendered on August 14, 1945, 6 days after Nagasaki. At the Moscow Conference held in December 1945, the United States, the United Kingdom, and the Soviet Union, with concurrence from China, arrived at a plan to occupy Japan. General MacArthur was vested with powers to issue all orders for the implementation of the terms of surrender, the occupation and control of Japan, and all directives supplementary thereto. He then, by the powers vested in him, issued a proclamation that established the IMTFE. The charter of the IMTFE laid out the jurisdiction, function, and composition of the tribunal. The charter had provisions allowing MacArthur to appoint judges to the IMTFE. These judges could be from the states that had signed Japan's instrument of surrender. These were Australia, Canada, China, France, India, the Netherlands, Philippines, the Soviet Union, the United Kingdom, and the United States. Over and above this, each of these countries also had a prosecutorial team. All the atrocities that the Japanese had committed from 1931, since the Manchurian invasion until the Japanese surrender in 1945, could be tried by this tribunal. Sir William Webb of Australia was the tribunal's Chief Justice. The tribunal consisted of judges of the respective countries nominated by these countries. There were 11 judges in all. MacArthur preferred a unified tribunal in which he appointed one chief prosecutor and 10 associated prosecutors. The accused were given a right to an attorney, but no formal provisions were in place for the appointment of defense counsel. The Japanese were not familiar with the Western style of trial advocacy, and they were not fully understanding or appreciative of the process created by the IMTFE. Judge Irma Northcroft suggested that at least one American lawyer be provided for each defendant. While the IMTFE had originally been envisioned as focusing specifically on Class A acts, evidence for Class B, that is war crimes, and Class C, wars against humanity, was also gathered. The accused persons were tried for Class B and Class C offences under the IMTFE only if they were concurrently tried for Class A offences as well. Joseph Caine served as a chief prosecutor of the International Prosecution section of the tribunal. He has been under criticism by historians for his orders to gather evidence via interrogations as opposed to a systematic collection of documents from government offices. The trials in Tokyo went on from May 1946 until November 1948. 9 senior political leaders and 18 military leaders were prosecuted by the IMTFE. One scholar was also indicted, but his mental illness led to the IMTFE dropping the charges against him. The royal family of Japan, including the emperor, were not under trial. They were allowed to keep the throne, but with diminished status. The tribunal delivered its verdict after 6 months of discussion and deliberation. Justices Webb, Haranilla, Bernard, Rowling, and the Indian judge Radha Binod Pal issued separate opinions. 2 of the accused passed away during the trial. For Class A, B, and C offences, 6 persons were put to death by hanging, while 1 was given the same sentence for Class B and C offences alone. The prison in which they were held was the Sugamo prison, the prison for all Japanese war criminals. They all died in the same prison. One educational concern featured in the minds of the planners of the IMTFE. They wanted the world to know the consequences of waging aggressive war. Now, why are these trials historically considered to be failures? Let us first examine the reasons for the failure of the Tokyo trial. In the Tokyo trial, the Allies followed a policy of no admission of aggression, no repentance and apology, and no compensation to their victims. Unlike the German example, the Japanese example is fraught with failures on the part of the United States to deliver what it should have and what it ought to have. A majority of the Class A war criminals in Tokyo were released without trial. Only 28 of the 70 Japanese apprehended for Class A war crimes were even brought to trial. The rest was split into a second and a third group and put on hold in the Sugamo prison. The first group of 28 were military, diplomatic, and political leaders. The 23 members of the second group and the 19 members of the third group were made of financial and industrial magnates, warmongers in ammunitions, trade, and notorious traffickers of drugs. Besides these, there were many Class A criminals whom General MacArthur set free in 1947 and in 1948. Many went back to politics under the cloak of democracy, but were still essentially fascists. The work of the Americans on Japan was not fully beneficial for a Japanese restoration and is not an experiment with positive results. As far as the Nuremberg trials are concerned, the trials failed to act as a deterrent to aggressive war. They even failed to act as a deterrent against the most horrible crimes of torture and genocide. This is evidenced since there have been countless wars of aggression and innumerable war crimes and crimes against humanity following the Nuremberg trials. No leader has been deterred from engaging in aggressive war or from ordering and committing war crimes and crimes against humanity in the international arena. The international community has not succeeded in creating a follow-up on the Nuremberg principles. As a result, in the 90s, we had several incidents of genocide. But with the Cold War's intrusive politics, the Americans slowly loosened on the sense of guilt that bound the Germans to the prisons. They were increasingly seen as well-behaved men who had turned harmless, aging and ailing, and were willing to be taken by their community gladly. The last of the trials was in 1948, and in a decade's time, America's policy completely removed all war crimes, and by 1958, all those convicts were no more in prison. This act belittled the severity of the crimes that deserved much longer jail terms. This was a key failure on part of American diplomatic policy. Punishment did not prevent war. Nothing stands as a testament to this other than the fact that the 6 decades after the Second World War, much blood has been spilled on the battlefield. It failed to show exactly what it meant by humanity. For instance, whether it referred to a specific standard of humaneness or whether it referred to humankind as a whole. The Nazi treatment of the Jews by any standard warrants punishment for itself. However, the legal interpretation of laws designated to punish such acts were given a less strict interpretation in the Nuremberg Tribunal. The crimes described thus far were interpreted as associated with warfare, and therefore it was not given a proper purposive interpretation. One must note that much of the pogrom against the Jews in the pre-war years were out of the temporal jurisdiction of the IMT. The IMT could only consider itself with acts done during the Third Reich. Subjecting the German leaders to foreign jurisdiction violated an important principle of national sovereignty and marked an invasion that was seemingly legitimate but not legally so. The IMT trials had, in effect, subordinated dominant state-centric law to international authority. Thank you.